All right, welcome back, y'all. This is Unit 3E, the right to die. We only have one case here, but it's a pretty big one. So, this is Washington State v. Glucksberg in 1997. It's a big case. It was a unanimous 9-0 reversal of the appeals court's en banc decision. And the question here is, does Washington's law against causing or aiding suicide violate the Constitution? And the court unanimously says no. Um, so basically, Washington says you can't kill yourself and you can't have doctor-assisted suicide. Um, the court had previously ruled in Cruzon that that a patient does have the right to turn down like water and medication, right? But they don't have the right to doctor-assisted suicide or to suicide themselves. Let's see. Yeah, Gluckberg is the doctor, basically, who wants to help his terminally ill patients commit suicide. And he contends, he bases this, again, on a 14th Amendment due process clause, and he contends that the existence of a liberty interest protected by the 14th Amendment, which extends to a personal choice by a mentally competent, terminally ill adult to commit physician-assisted suicide. And the en bancs, it went to the appeals court. The appeals court said no, and then the en banc, which means that everyone on the every judge on the district sits instead of just a 3-panel judge, and they ruled that you do have a 14th Amendment due process right to assisted suicide. And it concluded that the Constitution encompasses a due process liberty interest in controlling the time and manner of one's death. That there is, in short, a constitutionally recognized right to die. After weighing and then balancing this interest against Washington's various interests, the court held that the state's assisted suicide ban was unconstitutional as applied to terminally ill, competent adults who wish to hasten their deaths with medication prescribed by their physician. So they did limit it to only terminally ill, mentally competent adults. But the Supreme Court says no, absolutely not. The state's assisted suicide bans are not innovations. Rather, they are long-standing expressions of the state's commitment to the protection and preservation of all human life. We have always been reluctant to expand the concept of substantive due process because guideposts for responsible decision-making in this uncharted area are scarce and open-ended. By extending constitutional protection to an asserted right or liberty interest, we, to a great extent, place the matter outside the arena of public debate and legislative action. We must therefore exercise the utmost care when we are asked to break new ground in this field, lest the liberty protected by the Due Process Clause be subtly transformed into the policy preferences of the members of this court. Former cases were careful to allow individuals the right to, quote, refuse life-saving hydration and nutrition, but not to assisted suicide or personal suicide. And it says the Constitution permitted Missouri to require clear and convincing evidence of an incompetent patient's wishes concerning the withdrawal of life-sustaining resources. Okay, and then they break it down into like 6 big reasons why they disagree and that Washington has a right to make this law. Let's see. Number 1, Washington has an unqualified interest in the preservation of human life. The state's prohibition on assisted suicide, like all homicide laws, both reflects and advances its commitment to this interest. This interest is symbolic and aspirational as well as practical. As we have previously affirmed, the states may properly decline to make judgments about the quality of life that a particular individual may enjoy. This remains true, as Cruzon makes clear, even for those who are near death. The second point they make is that most suicides are influenced by severe depression or mental illness. And so we need to be very careful. The third, the state also has an interest in protecting the integrity and ethics of the medical profession. The AMA, like many other medical and physicians groups, has concluded that physician-assisted suicide is fundamentally incompatible with the physician's role as a healer. 4, The state has an interest in protecting vulnerable groups, including the poor, the elderly, and disabled, from abuse and neglect and mistakes. The Court of Appeals dismissed the state's concern that disadvantaged persons might be pressured into physician-assisted suicide as, quote, ludicrous on its face. We recognize, however, the real risk of subtle coercion and undue influence in end-of-life situations. If physician-assisted suicide were permitted, many might resort to it to spare their families the substantial financial burden of end-of-life healthcare costs. 5. This extends to protecting disabled and terminally ill people from prejudice, negative and inaccurate stereotypes, and societal indifference. The state's assisted suicide ban reflects and reinforces its policy that the lives of terminally ill, disabled, and elderly must be no less valued than the lives of the young and the healthy, and that a seriously disabled person's suicidal impulses should be interpreted and treated the same way as anyone else's. And finally, they say, this is a slippery slope. The state may fear that permitting assisted suicide will start it down the path to voluntary and even involuntary euthanasia. The Court of Appeals struck down Washington's assisted suicide ban only as applied to competent, terminally ill adults who wish to hasten their deaths by obtaining medication prescribed by their doctors. Washington insists, however, that the impact of the court's decision will not and cannot be so limited. If suicide is protected as a matter of a constitutional right, it is argued every man and woman in the U.S. must enjoy it. Thus, it turns out that what is couched as a limited right to physician-assisted suicide is likely, in effect, a much broader license, which could prove extremely difficult to police and to contain. Washington's ban on assisting suicides prevents such an erosion. And then Justice O'Connor concurs. She says the parties agree that in these states, a patient who is suffering from a terminal illness and experiencing great pains has no legal barriers to obtaining medications from qualified physicians to alleviate their suffering, even to the point of causing unconsciousness and hastening death. In this light, even assuming that we would recognize such an interest, I agree that the state's interests in protecting those who are not truly competent or facing imminent death, or those whose decisions to hasten death would not truly be voluntary, are sufficiently weighty to justify a prohibition against physician-assisted suicide. So the court is not having it. And it goes back to the states. All right, I'll see you for the next one. Have a great day.